And I'm coming to you, Zahid, now. And I wish, does anybody have a naughty question to ask from Zahid?
I'm guilty, you're right.
कोई मुश्किल सवाल किसी ने कुछ करना है तो, you know, I mean, I really, no, Zahid is obviously very, very well known to State Bank of Pakistan. And he's young, इनके सफ़ेद बालों पे बिल्कुल मत जाइएगा. He's definitely young, he's energetic, and he specializes in this. This is actually his field. That fintech, technology, you name it. And Zahid is the expert, and you'll also be pleased to know that he represents Pakistan in Tunis, in Morocco, and then this is the two countries that I know of, but there are so many others that Zahid can talk about. Zahid, nobody has a naughty question for you, just Sharifana Sawal. Now, Zahid, please share your perspectives on the existing regulatory framework in Pakistan pertaining to financial, fintech and cybercrimes. If you could, and any bilateral agreements that the law enforcement agencies have with global bodies, if you could talk about that. Then how would you propose improvements, including enforceability? I would request that since you are the expert of this field, fintechs, financial and cyber crimes, please enlighten us with your views here.
Thank you, Ji. First of all, thank you so much for allowing me the opportunity to be able to speak to this August gathering, and also to the organizers. I'd like to start off by maybe resetting the framework of what we're discussing from the morning till right now. Although this is about fintech and financial crimes and cybercrime, we've been focusing on the banks. All we've talked about is basically the bank, and whenever we looked at a regulator, we look at the state bank and we say, and I'm so sorry to be undiplomatic, that's just the way I am, I apologize. But we always look at the regulator, for instance, think a state bank ki responsibility hai. I'd like to basically say that let's look at anti-money laundering and financial crime in the generic sense, because it's more than just what happens with banks. I asked a question regarding cryptocurrency. It doesn't matter whether the state bank recognizes it or prohibits it, it exists. It's being used. It's on the dark web. What are we going to do about it? That's a response that our law enforcement has to have. So what I'd like to start off basically with is looking at the anti-money laundering law a little bit, maybe make some comments, then move on to the Anti-Terrorism Act, because that has an application to what we're talking about, and then go into the cybercrime legislation and then cybersecurity. I'm going to do this as quickly as possible, so apologies for being quick. You'd be surprised that the anti-money laundering, and somebody mentioned this morning, that 2010 se this law from 2010 has existed. Do you know that when was the first time, I'll see if anybody can answer this question, when was the first time that the AML Act, enforcement of freezing powers, was used? Just take a guess of a year. 2011, 2020, I mean, when do you think it was enforced? 2015. It took 5 years for the first freezing order to ever be issued. If any of you know Shahid Hayat, who live in this city, everybody knows him. He was the one, there was a case we were working on together. I was made prosecutor, and literally after 4 attempts of them trying, the judge would not allow the freezing. And I stepped in and then I got the freezing order. And it was literally amazing for the FIA, because they said, we've never had in the FIA under the AML Act for 5 years a single freezing order. That just talks about how implementation hasn't taken place. And in fact, his response to me was, I don't think we've ever tried it either. In NAB, there had been freezing. That's something NAB is and that has taken place over the course of years. So a lot of people start saying that legislation badalni padegi, hame framework banana padega. Actually, my response is, some of the frameworks are already there, but they're not being implemented, right? So think about the fact that we had to then take it up to the Supreme Court, and basically the Supreme Court was surprised by this, should you not issue notice to the person whose assets you're freezing? And that was the issue. And that would be ridiculous because the money would be gone. That was the kind of stuff we were discussing. Anyway, so that's an example of how implementation of the law around this needs to be still done and is not being done as much as we'd hoped it happening. Freezing orders, confiscation, etc. The other thing I'd like to sort of bring again to the fore is the Anti-Terrorism Act. So how many people can answer the question of who in Pakistan is responsible for anti-terrorism prosecutions and investigations? Who do you think? What entity is responsible? Federally, who is responsible? The reason why people can't answer this question is because actually there is none, right? And I'll tell you why. The FIA Act empowers, with some provisos in the schedule, the Federal Investigation Agency to look at interprovincial terrorism matters if the federal government allows it to do so. But basically, if you talk to the FIA and say, okay, do you investigate terrorism cases, the answer will be, hum to karte nahi hai. We don't do it. So who does it? Do you know who does it? It's the provinces. Do you know who the prosecutors are? Are the guys who paid 5,000 rupees for the per hearing. That's the status. The law is there. It's been there since 97 and improved for money laundering since till 2002. But we don't have, we talked about NACTA. NACTA actually, I'm sorry to be undiplomatic, does absolutely zero when it comes to investigation, operations, and prosecution. So at the end of the day, the person who's investigating is the IO, here sitting in police, CTD. The person who's prosecuting is the provincial prosecutor, bichara. Inki koi training nahi hui iske andar. They don't understand cybercrime. They've not had this kind of training. And the Federal Investigation Agency, which will actually prosecute and investigate everything from other frauds, absolutely has no role here. Zero when it comes to. So when we are criticized from outside saying, look, what are you doing about this issue? It is a fact that our regulators have already done their job. It is a fact that the legislation has already been passed. The problem is it's not being implemented operationally. That's why we need to move. And that is going to affect not just for money laundering and terrorism, which is something we've witnessed in the last 24 hours. It's going to actually impact cybercrime and the safety of Pakistan also. I'll give you a simple example. How many people can download the schedule number 4 from the website of the Ministry of Interior, which is supposed to be on the Terrorism Act? I mean, that should have been easy to do. Now let me come to the cybercrime. ETO 2002, basically, which I drafted the Electronic Transaction Ordinance, had 2 provisions of cybercrime. And on, where are you? Can you stand up for a second? This young gentleman, where is on? He was here a second ago. There he is. He's working for Teller now. He used to work for the National Response to Cybercrime Cell, which is the cybercrime unit of the FIA. And we can tell you that the industry sat with the Ministry of IT and developed an absolutely excellent legislation. I wrote that, he assisted in it, we argued, we debated, the FIA had a different view, the private sector had a different view, we got the legislation into Parliament. And then, I'm sorry, again, I'm being diplomatic, I'll take a name. The Minister for IT decided to completely change it, her own law. And today, that legislation which has been passed through Parliament, currently on every single provision of cybercrime, actually is not consistent with the rest of the world. We have an inconsistent cybercrime legislation from the rest of the world. That's a gap. You asked about a gap, I'm going to give you a gap. So, illegal access, inconsistent. Illegal interception, inconsistent. Electronic forgery, inconsistent. Electronic fraud, inconsistent. And I'm glad Hossein mentioned it. Most of it that's happening is regarding social networks. So that's a major gap. Your cybercrime legislation does not respond. For instance, if you, let me ask you a simple question. How many people, this morning we'd heard about this, people who, I think sir, you mentioned cyberbullying, that somebody will conduct a cyber attack, do an illegal intrusion, but not steal any money. Do you know under Pakistani law, under the PICA, this 2016 law, it's not an offense. It used to be an offense under ETO 2002, but when the new law came in, it required dishonesty. And the definition of dishonesty is that somebody who basically tries to wrongful gain or wrongful loss to take some money. So if I'm a cyber criminal, and this is news for everybody who wants to hack, go ahead and hack. You're legal in Pakistan to hack as long as you don't steal any money. So that would be something that we need to fix, right? That's an important fix that we need to make to legislation. Anyway, now, what can we do? And I'm coming to the last point that was or the question that was asked. Pakistan has the ability at this point to sign on to something called the Budapest Convention on Cybercrime. It is the only multilateral treaty related to cybercrime, and you don't have to negotiate its accession, you can just sign it. And any electronic evidence, not just cybercrime offenses, but any electronic evidence would become easily exchangeable between the country. That's something I would say would be something very, very useful. And actually the original legislation that we worked on actually was consistent with and based on that convention. So that would be something that we can take some advantage of. While the FIUs cooperate on anti-money laundering, for cybercrime and for electronic data exchange, that would be the one that you should try and basically put into place. And I just wanted to end with this one thought. On cybersecurity, I was so happy to hear, I think we heard from Bank Islami, the things that was said was surprising to me because actually I was hearing it for the first time from somebody. And I was surprised because when you talk about cybersecurity, the question that was asked, what's your communication plan? What is your cybersecurity leadership plan? What is your enterprise policy regarding cybersecurity? What about your systems? These are the questions that one asks when you're creating a management cybersecurity response. And one of the things we don't do necessarily is when we have a cybersecurity team that's been set up, we don't actually do drills. If you ask a person in the organization who's responsible when a cybersecurity incident takes place, who's the person who is going to be communicating with the media, who's the person who will be responding, this can be hazy sometimes. So one of the things I would say, this is something the regulator can do, is put into place something regarding cybersecurity to have a proper plan or guidance on how the banks need to have this plan and actually do drills. Some of them have. I've got Kamran sitting over there. I know he knows his job and I've worked with him. But there are a lot of other banks that may need some help over here. And I'll basically end with that with just one thought. Capacity building is absolutely essential. If the judges and investigators, prosecutors, NAB, FIA don't get it, we are not going to be able to make progress in this area. Thank you.
Thank you, Zahid. I think wonderful.